Loss of profit claims. These are the most controversially debated claims inside the industry and also in the arbitration or media. So let us understand what is the nature of the claim and what are the actual entitlements and how factually it can be claimed. Why loss of profit claims now? See, loss of profit claims have become one of the most debated topics in the construction industry. In many EPC or design build contracts, contractors invest significant time, manpower, sources, a huge capital which gets locked when there is no proper cash flow. And that results in loss of profits. So let us see what are the scenarios which may end up in loss of profits for the contractor. When projects are delayed, suspended, or partially omitted, that means descope, unilaterally by the employer, which is out of control of the contractor. For example, if an employer removes a major portion of the contract and if the descoping is very weak, it affects the contractor, then it ends up in the loss of profit claims. So, what is the philosophy, legal philosophy behind this profit of loss claim is whenever a damage is occurred to one party, the other party has to put back the financial position of the damaged party to the place where if this damage would have not been occurred. So that is the legal philosophy and the principle of damages behind the claims. For example, in fitting, you know that subcontract class 20.1 is used for claims and subcontract 17.6 limits the liability if the event even rise to the loss covered. And fitting is very fair and gives fair allocation where the profits can be claimed by the contracts. And many bespoke contracts, which are based on the common law jurisdictions, have recognized this allocation of the risk. And if the risk is foreseeable and it is directly caused by the Employers Act and it is properly proven with evidence, then the contractor is eligible for the loss of profit claim. So let us see what are the common scenarios which leads to the loss of profits. First one is the employer initiated suspension or termination without contractor's default, not under the umbrella of contract's default. If contractor's default, if it's terminated, they are not eligible for the loss of profit. But if it is terminated for convenience, it is terminated due to any other reasons that the employer can foresee, then it is not under the default of contract. Descoping or commissioning. So the contractor would have quoted the price, keeping in the mind that this is the lump sum amount of work which we are going to perform, under which we are eligible for the profit for so and so. But when a huge scope is being descoped, then it automatically puts him under pressure, and if the profit margin goes down, then they will not be able to provide the balance work at the same cost. And prolongation or the extended duration. If the duration is extended and there is an eligibility for the contractor for the prolongation cost, where the delay was purely due to employees' own delay, then the contractor is eligible for the loss of profit claim. And other than this, failure to provide site access, delay in approvals of the drawings, delay in approvals of the deliverables, everything will end up in loss of profit claims for the contractors. So, breach of contract or prevention principle, where the employers act prevent the contractor from perform. So, this is a very wide area where you can find that eligibility for the contractor for the loss of profit claim. So here is an example. For example, that's a design built railway project. if the employer delays access to certain sections for years, we have been worked in such projects, and later omits them from the scope, the contractor may be entitled to claim the loss of profit for that omitted portion, provided it can show that we are ready from our part and there is no delay from the part of the contractor, and the clear foreseeability was under the employer and the intent to perform was very clear by the contractor. Two principles play an important role in loss of profit claims. One is the principle of causation and the other is the principle of remoteness. So principle of causation is very clear. It is linked between the employer's action, such as suspension, omission, delayed approvals, and the loss of profit occur. So if there are concurrent causes such as contractor's delay, the claim will be refused or rejected. So coming to the remoteness principle, which refers to the damage was foreseeable at the time of contract formation by the employer. So that is a renowned case, Hadley versus Baxendale, which is 1854, that established that the damages are recoverable only if they arise naturally from the breach or where within the contemplation of both the parties where the contract was made. So it very clearly speaks about the foreseeability. So if the employer is omitting the work, the employer is foreseeable and they are aware of the original scope, and if it is the scope that affects the contractor, the contractor is eligible for the loss of profit claims. So how to quantify the loss of profit? So always the claim is in four sessions. One is the cause, effect, then entitlement, then substantiation. So quantifying comes under the effect. So what is the effect? So yes, you are saying that there is a cause. That doesn't mean that there is a damage. An effect should be there because of the cause. And the effect should be quantified in terms of time and cost for our usual claims. Loss of claim is only focused on the cost. So historical profit margin method, that you can show that these are the projects we have executed, these are the project margins which we have audited accounts. And from that, you can prove the profits. Tender margin method is that some tenders, like especially in public sectors for the road transport, they give a specific percentage for the profit. That for the projects of this range, like for below 50 million, it should be 15%, but after 50 million, it should be 10%, and above 500 million, it should be 5%. So something like that will be done. So that is a tender margin method. And resource utilization analysis, this is a bit complicated, but you have to show that the contractor staff's equipment overheads were underutilized because the project was delayed or descoped. So here there is a small example. If the tender margin was 12% and the employer descoped a huge chunk of work which is 10 million worth, and the contractor is eligible for a loss of profit of 1.2 million, which was the expected profit from that 10 million. However, the claim must be supported by very detailed tender build-up and financial evidence. So that's the most important part. Evidentiary requirement. So we have proved the cause, effect, entitlement. If only if you are entitling the contract, then you can go for this. Fourth one is evidentiary. Evidentiary is very, very important. Even though some contract doesn't have entitlements, you get the entitlement under the law. Because some contracts are silent on this. And if you are able to prove these both the principles of remoteness and causation, then you are eligible for the profit claim under the common law jurisdictions. Evidentiary requirement is that you have to prove the evidence, how demonstrate the loss of profit. First is a detailed tender analysis, profit built up from the time of bidding, project cost and revenue data from similar completed projects. You have to store your history from the audited accounts, correspondence and records proving that the employer's action caused the losses. And you can go with the independent expert reports from forensic accountants or quantity surveyors to validate the calculations. So loss of profit claims, there is a myth in the arbitration arena that mostly it gets rejected. It gets rejected because there is no proper evidentiary backups. There are many cases, even critic-based contracts, which we have worked, we have claimed the profit of claims, and there are many such successful claims which you can see in the public records. The reason is you should have a proper backup evidences. So large contractors, MNCs, global contractors, they do this because they are very well from the day one. They work with the mindset that this will end up in arbitration. We need the evidences, but tier 2 and tier 3 sized contractors, they don't keep these evidences. So see, what we request is that to keep this evidence or always part of the system. You don't have to maintain this only for arbitration or for dispute resolution. You have to maintain to understand what is your history, what is your lessons learned, how you are going to transfer to the next project. A lessons learned from one project can save 5 projects, which we have practically worked. So do this with the mindset of expansion of the business. See, all these discussions about claims end up in one thing. We have to run the business profitably. And construction is one of the largest industry, the most demanding industry for the world's transformation. And we are contributing to the world's GDP to a very greater level. And we are committed in raising the lifestyle of every individual of the world. So such industry has to be profitable, and such industry has to survive with a larger impact on the humankind. So that is the reason why we are discussing this again and again behind this. We'll go to the next slide. What are the defenses commonly raised by the employers? First defense is very easy, that profit was not guaranteed or was speculative in nature. Second, the most important thing, this I always be on the side of the employer when it comes to mitigation, because the employer cannot mitigate the losses because the execution is done by the contractor. The contractor has an ethical and legal obligation to mitigate the losses. If they have failed so, and that's put them on the back foot. Exclusion or limitation clauses, they prevent the recovery of the indirect or consequential losses. So that are one of the defenses. Concurrent delays. See, if the contractor is blaming the employer that the employer has not given the site access, at the same time the contractor is not ready to perform even if the site access was given, then the contractor cannot ask that it is an employer forcibility and it is purely by the employer delay. No, if the employer proves that the contractor was not ready at that time and it is a concurrent delay, it's not just a delay from our end, then that the eligibility of cost, not just loss of profit claim, the entire EOT claim or prolongation claim is not eligible for the contractor during the concurrency period. Address risk allocation explicitly. Most contract experts forget that contract is a risk allocation matrix. Let's see the legal proceedings which are available, like Hadley and Baxendale, which we saw already, which is brought the rule of foreseeability of losses. In Commonwealth versus Amman Aviation 1991, the court recognized the loss of profit as a legitimate expectation damages. In several international arbitrations involving free contracts, tribunals have accepted profit margins based calculations if the contractor could demonstrate the readiness to perform and if the descoped works were part of the original contract scope and they were awarded with the profit of claims, loss claims. So these cases show that while tribunals are open to avoiding, it's not that the arbitrations they don't provide. I work with many lawyers who they say that no, loss of profit claims is just removed. We will not be able to. No, you will be able to claim only when you have a proper. So focus on the proper evidence, and you can't blame the lawyers because they commit the last part. What you do as a contractor and your project team does while executing the project is more important. best practices for the contractors. So clearly include profit margins and overhead buildups. Be transparent. If you want to hide your profit, then you will end up in huge damage. Keep accurate costs and progress records. Keep records for the costs, always. Notify claims promptly. Here is where the most contractors fail, especially tier 2, tier 3 contractors globally. And tier 2, tier 3 contractors forms the 95% of the contractors, not the tier 1 contractors. They only handle the large part, the creamy layer of the construction industry. The entire industry is built up with tier 2 and tier 3 contractors. So retain independent experts or hire consultants who have experience in this. During contract negotiation, insights and insistent, including clear descoping or termination valuation clauses. So that specify how profit will be treated if work is committed. Please be cautious while drafting these clauses. So how to turn this lessons learned into strategy? So loss of profit claims are not merely financial claims, they represent a deeper principle of fairness in the contract. When one party prevents the other from earning his legitimate returns, compensation is a matter of equity as well as law. For contractors, these claims highlight the importance of robust record keeping, transparent enterprising, and early communication of the impacts. For the employees, they emphasize that the need for the fair risk allocation. Don't behave like that you can do anything in your adherence to procedural good faith. In the end, a well-prepared loss of profit claim can transform a potential loss into a justifiable recovery and strengthen the overall integrity of the commercial relationship, the transaction decision. Glad you like this part. And if you want to have corporate trainings or if you want to have any consulting or you are ready to submit a claim, it has to be vet by some experts or you want to prepare the claim from the scratch, our team can help you. You can contact the below numbers. Thanks for watching. Take care.